Hello, everyone. Thank you for coming to the first edition of our monthly lecture series on landmark judgments of the Supreme Court. Before I start, I want to take a moment to express my solidarity with Mr. Prashant Bhushan, who has found himself on the receiving end of what can only be described as a travesty of justice, criticizing the Supreme Court and expressing the opinion, whether right or wrong, that the court, through its judgments and orders, has caused damage to democracy, is the fundamental right of every citizen. And there is no better time to remember that than on Independence Day, when we recall the freedom struggle that gave us this independent nation and this constitution. So I just want to start by acknowledging that. That said, today we begin our lecture series with the first fundamental rights case decided by the Supreme Court of India, A.K. Gopalan versus State of Madras. It is a legendary case, and as is often the case with legends, the myth-making around it has tended to outpace the reality. I will say more about that, but I want to begin this story elsewhere. I want to begin it in France in the middle of the 19th century, almost exactly 100 years before the Constitution of India was framed. Now, the French, as I'm sure all of you know, are an interesting people. Every few decades, they decide that life has become a little boring, and the only way to spice it up is to organize a revolution. One such revolution took place in 1848, when King Louis Philippe was overthrown and a republican form of government established. At that time, a constitution was drafted. This constitution had a range of civil rights, free speech, freedom of the press, and so on. And these rights were the outcome of concerted struggle, much like our own constitution at the end of our own freedom struggle. But very soon, despite the existence of this constitution, the aspirations of the French people were brutally and violently suppressed by the authorities. And the constitution, it was seen, did not come to the rescue of the people. Watching all this happen, a keen observer remarked, and I quote, "For each paragraph of this constitution contains its own antithesis, its own upper and lower house, namely liberty in the general phrase, abrogation of liberty in the marginal note. Thus, so long as the name of freedom was respected and only its actual realization prevented, of course in a legal way, the constitutional existence of liberty remained intact, inviolate, however mortal the blows dealt to its existence in actual life." This astute observer was a man named Karl Marx, whose name you have probably heard at some point. And in these lines, Marx offered us an important insight. A constitution that is framed as the outcome of a revolution or a freedom struggle is a document that is made up of both sunlight and shadow. It is a promise of liberation, but also a charter of servitude. Upon the terrain of the constitution, liberatory and repressive impulses are perpetually at war with each other. At any given point, it is the actions of constitutional functionaries, the power of social movements, and the interpretations of the courts that allow one or the other side to prevail. But the struggle between the two is a continuing one, between the emancipatory and the repressive sides of a constitution. It's never just one or the other. Now, A.K. Gopalan is an important case because it was the first time that these conflicting impulses contained within our constitution came to a head before the Supreme Court of India. In many ways, the choices that the court made back then are still with us today. And that's why it is important to go back to the beginning and study this judgment carefully. But before we do that, who was A.K. Gopalan and why did he come to the Supreme Court? A.K. Gopalan was born in 1904. He began his political life with the Indian National Congress during the freedom struggle, participated in the Khadi movement, was arrested for his involvement with the salt satyagraha, he gradually moved leftwards and joined the newly formed Communist Party in 1939, and then was jailed by the British for many years in the 1940s. He escaped, was caught, was jailed again, and so on. In fact, at midnight on the 15th of August, 1947, when India was awakening to life and freedom, Gopalan was in jail. And in one moment, he went from being a prisoner of the British to a prisoner of the newly independent Indian state. He hoisted the tricolour in jail, gave a speech, and was promptly booked for sedition for inciting enmity against the British king. In court, Gopalan said, look, the whole point of spreading disaffection against His Majesty's government was to bring it down. And today it has all actually been brought down. So why am I here? Isn't this ironic? The court did not see the irony. When he was not released, there were widespread protests in Kerala. And Gopalan wrote, I was a political prisoner from 1930 to 1945 in the eyes of a foreign government. Under today's popular government, I am branded a criminal. He was eventually released in October 1947 and then rearrested, a story that is probably familiar today. In December, he was rearrested under preventive detention law. He was still in jail when the Indian Constitution came into force. So Gopalan's story, a story you can read in more detail in his autobiography, a fascinating book, thus epitomized the fundamental question. On the 15th of August, this day many years ago, did we Indians actually move into a life of freedom, or did we simply swap one set of masters for another? The Indian Constitution was supposed to answer that question and answer it in favor of the former. And it was Gopalan who first posed that question in direct terms. As I said, in 1950, when the Constitution was enacted, Gopalan was still in jail. And his detention, along with the detention of thousands of others, which would have become illegal because of the newly minted Article 22 of the Constitution, which did not allow preventive detention unless specifically authorized. His detention and all the other detentions had now been regularized under the Preventive Detention Act of 1950. This act, that was in large part based on colonial laws, but in some respects, as we will see, went even further than colonial laws, did a series of things. It authorized preventive detention upon the subjective satisfaction of the government. It provided from the 7th schedule of the Constitution a list of subjects for which constitutional safeguards, such as the review of detention by an advisory board, were done away with. And it barred courts from looking into any material that constituted the grounds upon which an order of detention was passed. Again, some of this may sound a little familiar. Gopalan applied for a writ of habeas corpus. And in doing so, because the ostensible justification of the detention was the act, he challenged the constitutionality of the Preventive Detention Act. As the legal historian Kalyani Ramnath tells us in a fascinating paper titled ADM Jabalpur's Antecedents, Gopalan was taken from Madras to Delhi in a first-class train carriage, guarded by 2 inspectors and 12 policemen. And once he got there, he began to go on a hunger strike. Today, as we all know, Gopalan in large part lost his case before the Supreme Court. The act was upheld, barring the provision, section 14, that barred the court from looking into material that was the ground of the order. Barring that, the rest of the act was upheld and the application was dismissed. K.G. Kannabiran, the great civil rights lawyer, in his book, The Wages of Impunity, calls it the first Indian-made foreign judgment. Now, the legend around Gopalan's case and its afterlives goes something like this. Over a heroic dissent by Justice Fazl Ali, a majority of the Supreme Court, that then sat in a panel of 6 judges, dismissed Gopalan's petition on 2 grounds. First, that the fundamental rights under Part 3 of the Constitution operated in separate silos. That is to say, a law dealing with preventive detention, and therefore ostensibly falling under Article 22 of the Constitution, that specifically authorizes this kind of detention subject to certain safeguards or not. Such a law could not be tested on any other article of the Constitution, like Article 19 that allows for free speech, freedom of movement, and so on, because detention obviously affects those rights, but that could not be done. Or Article 21 that guarantees the right to life and personal liberty. So such a law could not be tested on the touchstone of these articles. And secondly, the word law under Article 21, which prohibits the state from depriving any person of their life or personal liberty, except in accordance with procedure established by law, was limited merely to the existence of a formal law that had been validly enacted by the state. So law in Article 21 just meant that the procedures that are preconditions for passing a valid law have been complied with. And so you cannot go further on challenging detention. This hyper-formal reading of Gopalan, so the legend continues, held the field for the next 25 years until Maneka Gandhi versus Union of India, relying upon the bank nationalization case, overturned it and inaugurated the birth of a new constitutional era premised upon freedom and due process, a development that was recently endorsed by the 9-judge bench of the Supreme Court in the privacy judgment. So that's the popular legend. Let me just say a couple of things about that. First, the fact that Maneka Gandhi actually lost her case, something you don't actually find out until you read all the way up till the final line of the judgment, when you find that she didn't get her passport back, should give us pause before we proclaim that judgment as some great harbinger of freedom. And secondly, this legend and this story simply does not square with the reality that we see around us today, a reality in which our judiciary is quite simply absent when it comes to the cases of administrative detention and personal liberty. Even as I speak, let me remind you of a man named Dr. Kafil Khan, who has been in prison without trial under the National Security Act for many months for making a speech. His habeas corpus petition has been heard twice by the Supreme Court and 15 times by the High Court to no avail. If Maneka Gandhi actually meant anything at all, more than the barest of platitudes, this would never be allowed to stand. If Maneka Gandhi actually meant anything at all, then the most recent data of the NCRB that shows that there are more than 1 lakh people in India who suffer some or the other form of preventive detention, which means, and just to clarify, detention without trial, without being found guilty of an offense, but on the suspicion that you might commit an offense. This statistic is shocking, and if Maneka Gandhi meant something, this would never be allowed to stand. So what's wrong then? My suggestion is that for many years, we have been drawing an entirely wrong set of conclusions from the Gopalan judgment. It is true that the majority was wrong, and Justice Fazl Ali in dissent was right. But the reasons why that was so were not the reasons the Supreme Court found persuasive in Maneka Gandhi. The Supreme Court formally overruled Gopalan, but it did so for all the wrong reasons, and so the ghost of Gopalan survived Maneka Gandhi and continues to haunt us today. And it is that which causes this great divide between the rhetoric that we keep hearing from the Supreme Court about how it is the guardian of liberty and the reality which is that it is not. And therefore, if we are to have any hope from the future, we need to go back to the basics. We need to go back to Gopalan. We need to understand why Justice Fazl Ali was right when he struck down the detention and when, according to him, Gopalan deserved to walk free. And on that basis, craft a progressive jurisprudence out of the embers of that dissenting opinion. So then let's come to Gopalan, the judgment, not the person, who had an illustrious political career afterwards, incidentally. He often said that stop detaining me and meet me at the polls so we can discuss civil liberties at the ballot box with Nehru and Rajagopalachari. That's an interesting aside. Now, in the Gopalan case, Gopalan's lawyer, the legendary Nambiar, raised three principal arguments. First, he argued that preventive detention, by its very nature, infringed upon the freedom of movement guaranteed by Article 19, Subclause 1, Subclause D of the Constitution. Because when you are detained, you literally cannot move. That's the point of detaining you. And so, therefore, any such order would have, and any such law that authorized detention would have to be tested on the touchstone of Article 19, Clause 5, that allowed for reasonable restrictions to be placed upon the exercise of the freedom of movement. If you have a constitution with you now, it would be a good time to open it and just track these articles as we go along. So that was Nambiar's first argument, that when you detain someone, you are stopping them from moving around. In fact, you are detaining them because you want them not to move around and spread their ideas and commit crimes or whatever you suspect them of. And therefore, you need to test that restriction on the basis of Article 19, Clause 5. Nambiar's second argument was that under Article 21, a law that sought to deprive an individual of their personal liberty, which detention does by definition, had to conform to some basic substantive standards of natural justice, which the Preventive Detention Act did not. Notice, hearing, an impartial tribunal, things like that. The very idea of law, the word law, included these standards. That's what distinguished a law from just a command or an order or a firman. And Nambiar's third argument was that even if you took the text of Article 22 itself, which specifically authorized preventive detention in certain specific cases, this law went far beyond even that. And we'll come to that in a few moments. So these were Nambiar's three arguments. The Detention Act violated Article 19(1)(d), freedom of movement, Article 21, right to life and personal liberty, and even violated Article 22 that allowed for this kind of law to be made. So therefore, it was unconstitutional. If it was unconstitutional, Gopalan's detention was without the authority of law and therefore automatically lapsed, and the habeas corpus had to be granted. That was the structure of Nambiar's argument. Now, the bench of 6 judges split on each of these 3 questions. Not as we popularly think as a straight 5-1, but in different ways. Each of the 6 judges authored an opinion. So you have 6 different opinions, a habit that began early in the Supreme Court's history and continues today. Now, none of the 6 judges, and this is something that Sirvai points out, and so does Kanabiran, actually held that Article 22 is a complete code for detention. Justice Mahajan arguably did so, but even there it is ambiguous. But at best, only one judge did. So this whole legend that Gopalan held, that Article 22 was a complete code, you had like silos, and so you couldn't read in rights into each other, and that was overruled by bank nationalization, and Maneka Gandhi relied on that, is simply a misreading of Gopalan, because Gopalan never said that. So that has to be gotten out of the way first. The specific first question was whether, constitutionally speaking, preventive detention had to be tested on the touchstone of the freedom of movement clause, Article 19(1)(d). On that question, 4 out of 6 judges held that it did not have to be tested. Chief Justice Kanya, Justices Shastri, Mukherjee, and Das held that the kind of movement that was spoken about in Article 19(1)(d) was actually referring to the idea of India being a territorial unit. And therefore, you cannot place arbitrary restrictions upon people moving within India from place to place. So states can't put up borders unless you have scheduled areas where scheduled tribes live. So there can't be restriction on that kind of movement. And they drew upon the fact that the article uses the word movement in the territory of India, has provisions for scheduled tribes, to hold that actually it wasn't about detention and physical movement, but movement in India. That was the argument they made. Justice Mahajan expressed no opinion on this issue, at least that's my reading of his judgment. Justice Fazl Ali, on the other hand, in dissent, said that how can you possibly read any such artificial restrictions into Article 19(1)(d)? The article says freedom of movement. Quite literally, detention is meant to curtail a person's freedom of movement. Kanabiran, in his analysis of this judgment, goes one step further and says specifically that preventive detention has always been a political tool. And the whole purpose that this tool served in the colonial era and continued to do even after was you had these inconvenient people who were saying inconvenient things, and to stop them from getting around, you physically restrain them. So the whole purpose of detention was to stop you from moving around anywhere in India. And so it just strains logical sense to limit and separate the articles in that way. And Kanabiran says that if you actually were to read the Constitution informed by the freedom struggle, informed by the ways in which the British used to restrict political leaders' movement by using these laws like this, then you would have found the other way. You would have agreed with Justice Fazl Ali. So that was the first point of distinction between the majority and the dissent. Now, on the second issue, and here is where things are interesting, the split was far closer. The second issue, to remind you, was what does the word law under Article 21 actually mean? Is it just a formally enacted valid law, or is it something more than that? On this point, three judges, Chief Justice Kania and Justices Mukherjee and Das, held that the word law under Article 21 simply meant a validly enacted law, nothing more. They relied upon the CADs, the debates, the Japanese constitution, which had a similar phrase, the use of due process in the American Constitution, its absence in the Indian Constitution, to come to this conclusion that law just means that the formal requirements of lawmaking are fulfilled, majority in the parliament, so on. Justice Mahajan, again, in my reading, did not express an opinion on this point and specifically says that he's not expressing an opinion on this point. And two judges, Justice Fazl Ali and Justice Shastri, held in different ways that the word law did mean something more than enacted law. So what you actually had out of a bench of 6 judges was a plurality, not a majority, of 3, who held one way, 2 who held the other way, and 1 who expressed no opinion. It's also important to note, and I want to stress this, the argument in Gopalan about the scope of Article 21 and the meaning of the word law was not the same as the argument that was finally accepted in Maneka Gandhi's case. It wasn't about whether a law under Article 21 has to be just, fair, and reasonable in a substantive due process sense. It was simply that for something to be even called a law, it had to subscribe to a basic minimum threshold of substantive content that was common to civilized legal systems. That is, notice, a chance to be heard, and an unbiased adjudicatory body. And so you can't have, the very meaning of law requires these basic procedural ideas. Otherwise, there's no distinction between a law and just an act of will or a robber gang imposing its writ, whatever it might be. So you have to separate the law from that kind of exercise of force. And that's why it's somewhat puzzling to read the majority's concerns with American-style due process creeping into Article 21 that would turn it into a repository of judicial desires, something that did happen in Maneka Gandhi and has happened after that when Article 21 has become something, wide-ranging and endless. But that was never even argued in Gopalan. Nambiar never argued that, and that was never at issue. The argument simply was that law isn't law without some minimal content of natural justice. And it was that position that found favor both with Justice Fazl Ali and with Justice Shastri. So that was a slightly more complex debate than Gopalan is often given credit for. And Maneka Gandhi's overruling then did something totally different. It went down a different route of substantive Article 21 and not the really important procedural safeguards that Justice Fazl Ali and Justice Shastri would have read into Article 21. And that's one major point of divergence here. Because if those safeguards were read into Article 21, then you would have a much more progressive, civil liberties oriented jurisprudence that would hold and force the state to subscribe to these kinds of basic principles when it tried to deprive you of your core liberty. So that part of Justice Fazl Ali's dissent, that part was not what Maneka Gandhi focused on. That part was never something that was resurrected in future years. That part has been ignored. But this idea that Article 21 then has become the repository of everything that anyone wants at any given time, that's what ultimately won the day. And that, in my view, is and has been a mistake because it doesn't do anything. It doesn't protect you when the state actually comes for you. And that we have seen over the last 35, 40 years. I think the evidence on that is simply unanswerable now. But it's on the last issue, that is on the actual content of the Preventive Detention Act, that I want to focus on. Because as we have all seen by now far too many times to count, it's easy to lay down grand principles of constitutional law, liberty, and equality, and then fail to apply them to the case at hand. Maneka Gandhi being a good example of that. In Gopalan, the main debate around the law turned upon Section 12 of the Preventive Detention Act. Now, under Article 22, Clause 4 of the Constitution, it was then provided that a preventive detention law cannot authorize detention for more than 3 months unless an advisory board reviews the case and opines that there is sufficient cause for the detention. That is Article 22, was Article 22, Clause 4. Under Article 22, Clause 7, 3 clauses down, Parliament was also allowed to make a law that it could prescribe the circumstances and the classes of cases in which a person could be detained for longer than 3 months without obtaining the opinion of the advisory board. The competence of Parliament to pass these laws, of course, flows from Article 245. And according to the 7th schedule, the fields for which these laws under 22(7) could be made included defense, foreign affairs, security of India, security of a state, maintenance of public order, and maintenance of supplies and services essential to the community. Now, what Section 12 of the Act did was it picked up all these categories, but for the last one, to maintenance of supplies, it picked up the first 5 categories from Schedule 7 of the Constitution and then put them into the Act and said, for all these categories, the Article 22, Clause 7 exception applies. And for all these categories, people can be detained for 3 months and more than 3 months without any review by the advisory board. So effectively, and just to kind of a TLDR summary of this, the 7th schedule said that there are these 6 categories for which Parliament can pass laws of preventive detention. Article 22, Clause 7 said that in some cases, Parliament can pass a law that would allow detention for more than 3 months without advisory board stepping in. In this Act, Parliament said that we will just take all these categories for which we have the power to pass these laws, and for all of them but one, we will have the most stringent possible situation, which is that you can be detained for more than 3 months without an advisory board intervening. So it basically was pushing its powers to the absolute limit under this law. Now, 4 judges out of 6 saw nothing wrong with this. They said, look, Article 22, Clause 7 says, Parliament can prescribe the circumstances and classes of cases under which this can happen. Parliament has done that. We, the court, we don't like it. And they all said we don't like it. They said we don't like it. This is really bad. And the very idea of this kind of detention is an anathema to civilized countries. But there's nothing we can do about it. Because we are the court, we don't frame policy. We just test it on the touchstone of the Constitution, which is a fair enough argument in its own right. And in fact, but the court went further. Responding to a challenge that these classes of cases were too broad, it actually endorsed the government's argument, agreeing with the government that emergency situations could not be predicted. A culture of deference that has unfortunately come down to us to this day. And this is where Justice Fazl Ali's dissent becomes really important. Because Justice Fazl Ali began his analysis with a different interpretive framework. He specifically noted that because the provisions being interpreted were meant to serve as safeguards for the individual, they had to be interpreted in a manner that was favorable to that individual. And he actually followed up on that in interpreting the Act. So he observed that under the scheme of Article 22, the existence of the advisory board that had to review the legality of detention was the general rule, because the idea that an impartial tribunal must test the infringement of your liberty, that was the core of the constitutional commitment to freedom and liberty and so on. So the existence of the advisory board was the rule. And Article 22, Clause 7, that allowed Parliament to do away with the advisory board, was an exception to that rule. And this difference between the rule and the exception was fundamental. In words that echo and which have unfortunately never been heeded by the Supreme Court for all its lionizing of this dissent, Justice Fazl Ali observed that the Parliament cannot, by its own will, treat the normal as the abnormal and the exception as the norm. But that's exactly what had been done. What Parliament had done was to take the 6 categories under Schedule 7, for which it was competent to pass preventive detention laws, and just say in a blanket fashion that for 5 of these 6 broad categories, the advisory board would be dispensed with. So no advisory board for these 5 categories. This, for Justice Fazl Ali, showed a clear non-application of mind by Parliament. It had simply picked language from the 7th schedule and reproduced it in the law. Something that's happened regularly after that, across the board. Anytime the Parliament wants to restrict free speech, they will just pick 19 Clause 2 categories and just put that in the law and say, hence proved QED. And that's unfortunately been allowed to fly by the court on multiple occasions. Furthermore, and contrary to the majority, Justice Fazl Ali held that since Article 22, Clause 7 used the phrase circumstances and classes of cases, the word and would have to be given its natural meaning. Thus, the words circumstances and classes had to be read disjunctively. Parliament's law would have to prescribe both the circumstances and the classes of cases where the advisory board had been done away with. The categories under the 7th schedule, however, only spoke to the former. Consequently, as the learned judge observed, the class or classes to be prescribed must therefore have a direct bearing on these matters and must be so selected and stated that anyone by looking at them may say, that is the reason why the law has prescribed prolonged detention without reference to an advisory board. In other words, and this is continuing with the quote, there must be something to make the class or classes prescribed fit in with an extreme type of legislation, some element of exceptional gravity or menace which cannot be easily and immediately overcome, and therefore necessitates prolonged detention. And there must be something to show that reference to an advisory board would be an undesirable and cumbersome process and wholly unsuitable for the exceptional situation to which the law applies. Close quote. However, by mechanically reproducing the categories under the 7th schedule, Parliament had clearly failed to apply its mind to prescribing the circumstances and classes of cases where the gravity and severity made it okay to bypass the essential safeguard of the advisory board. Indeed, as a coup de grace, Justice Fazl Ali found that the colonial preventive detention legislation had actually been more specific than the post-colonial Preventive Detention Act. And not only that, the preventive detention laws in wartime England were more protective than the peacetime law that was this act. For this reason, Justice Fazl Ali struck down the act as unconstitutional. And had he been in the majority, Gopalan would have walked free. Now, what this analysis, I hope, explains is that the difference between Justice Fazl Ali and the majority, part of the majority, was not merely a difference about the relationship between Articles 19, Clause 5, 21, and 22, although it was about that. The difference in itself is important but insufficient. As we have seen, you can gloriously hold that all the provisions of Part 3 are to be read as a whole, that laws under Article 21 must be just, fair, and reasonable, and that detention must be tested on the touchstone of every fundamental right, and then still uphold every single law and every single detention under that law that comes before you. We have seen it's perfectly possible to hold both these ideas if you're the judiciary. That, I would say, is a sleight of hand, but obviously that's my view. But the difference between the majority and Justice Fazl Ali, and in this he was joined by Justice Shastri, was a deeper difference about fundamental questions of constitutional value. The majority said, look, we don't like these laws. We think preventive detention is a bad thing, but what can we do? Article 22 authorizes this. That's all our role as the court ends here. Justice Fazl Ali, on the other hand, said that given that these preventive detention laws are an anathema, given that they are meant to be exceptional, we will treat them as exceptional, which means we will interpret them in a way that, consistent with their language, they place the highest possible burden upon the state and are interpreted as sensitively to the rights of the people as possible. And the result of this was that Justice Fazl Ali didn't need to adopt any interpretive fireworks or grand rhetorical statements to do his job. Just on this principle, the act failed and was struck down. And on a different day, a man would have regained his liberty. And I wanted to compare that with Maneka Gandhi, where every grand statement imaginable was made and she still didn't get her passport back. I want you to compare that with Anuradha Bhasin, where every grand statement was made, but the internet continues to be restricted in Kashmir and it's been shut down today, in fact. What lessons you draw from this, of course, I'll leave that to you. So to sum up the difference, the majority saw Article 22 as authorizing preventive detention and its role as, therefore, interpreting what that meant. Justices Fazl Ali and Shastri saw 22 as placing safeguards for the individual and putting limits upon preventive detention, and therefore they interpreted this as an exceptional situation that has to be narrowly construed. And the core difference lay there between these two approaches. And that choice the court made to go with the first idea that Article 22 and detention was just a normal part of the Constitution, a part you dislike, but it's still normal and you must defer to the state like you would do ordinarily, all of that. That is what haunts us today in all these cases where you deny bail under the UAPA, all those cases where, again, there is no scrutiny of detention under the NSA and so on. And Justice Fazl Ali and Justice Shastri's views on this, that you need to treat these as exceptions and interpret them in the strictest possible way and in the way that is most conducive to individual liberty, is the forgotten part of Gopalan that even Maneka Gandhi and more lately Putuswamy's judgment have not touched upon. Now, in the final part of this lecture, I want to locate Justice Fazl Ali's dissent in constitutional history. When he said that Parliament could not by its will treat the norm as the exception and the exception as the norm, he was referring to a specific history. It was the colonial legal regime that had established what we can call a permanent state of exception. anchored to the sweeping powers enjoyed by an unelected political executive, the Governor General. The Governor General's office was vested with the power to issue ordinances having the force of law in emergencies, and this power was often used to authorize preventive detention. Even after the incremental growth of representative institutions in India under the 1919 and 1935 Government of India Acts, the Governor General continued to possess overriding powers of legislation, effectively making the partially elected assemblies subservient to the executive. These powers were at the Governor General's satisfaction and therefore virtually unreviewable. While executive supremacy exercised through ordinances was most frequently in use during the two world wars, there existed a parallel legislative and executive framework that replicated the features of the state of exception, even in peacetime. As early as 1818, the Bengal Regulation authorized preventive detention for the preservation of tranquility and security from either foreign intervention or internal commotion. In the interwar years, the notorious Rowlatt Act, which became the flashpoint for nationalist protests, authorized preventive detention for up to 2 years. The Emergency Powers Ordinance of 1932 was used both to ban organizations and to impose a regime of detention. Needless to say, this regime was criticized by the freedom movement. The critique of the regime was primarily political, of course, but also took a constitutional form. Soon after the passage of the Rowlatt Act, in 2 annual sessions of the Indian National Congress, separated only by 3 years from each other, the presidential address focused on the relationship between personal liberty and executive power. In his 1919 address, Motilal Nehru critiqued the Rowlatt Act, specifically for its endorsement of executive supremacy, and argued that just because there are some persons who may endanger public safety, the whole nation cannot be asked to submit to the disgrace of allowing this terror to hang over it. And the sole judge of the innocence or guilt of any person is the executive, and that is something that is wrong. As an ironic aside, when the Preventive Detention Act was being passed in 1950 and subsequently been extended in the independent India's parliament, Nehru was reminded of his father's speech and was asked in anguished terms that why is the son, does the son not remember what the father said way back when the British were still ruling us? Unfortunately, it had no impact. After pointing to various aspects of the Rowlatt Act that enshrined executive supremacy, Nehru, that is Motilal Nehru, noted, no executive in the world, however competent it may be, has any business to usurp the jurisdiction of duly constituted courts or deprive the people of the protection afforded by them. He went on to specifically reject what was accepted in the majority of Gopalan, that the exceptional situations could be invoked to justify these laws. And indeed, he articulated an alternative framework focused on the inviolability of our civic rights, precluding such a reign of terror that might be initiated by a panic-stricken executive. 3 years later, in 1922, C.R. Das observed in his presidential address, the personal liberty of every Indian today depends to a great extent on the exercise of persons in authority of wide, arbitrary, or discretionary powers. Where such powers are allowed, the rule of law is denied. Familiar, very familiar. Das used this framework to critique the Bengal Regulation of 1818, as well as the Criminal Law Amendment Act of 1908 and the Prevention of Seditious Meetings Act of 1911. Das noted that the concentration of power in the hands of the executive was objectionable, not because it was never exercised for the safety of the nation, but because the very existence of this power was inconsistent with the existence of individual liberty. And making an impeccable argument against the logic of the exception, Das concluded by arguing that only if you have recourse to law and order to establish and defend the rule of law is your law and order entitled to claim the respect of citizens. More specifically, soon after the lapse of the Rowlatt Act, in an otherwise conservative set of lectures titled The Rights and Duties of the Indian Citizen, the writer and legislator Srinivasa Shastri took specific aim at the 1818 Bengal Regulation and its progeny, and noted that to arm the executive permanently with the power to take away a citizen, lock him up, and refuse to even bring him up to trial is nearly a direct repeal of the liberty which is the most important, the liberty of the person. Again, very familiar. We can therefore see that the attainment of independence in 1947 was preceded by an almost 3-decade-long civil liberties tradition that had 3 salient features. First, it defined personal liberty in opposition to concentrated state power. Second, it critiqued the different aspects of the state of exception, such as preventive detention and so on. And thirdly, and most importantly, its arguments were universalistic in cast. They were not couched against the British government as an alien foreign power, but against executive power more generally. This is especially significant when we consider the fact that these arguments arose in the wider context of a movement for national self-determination. But as far as personal liberty was concerned, they transcended that immediate context. They would therefore remain applicable even after the government was no longer foreign or alien, but of the people. Now, despite this tradition, the Indian Constitution does provide, as the majority in Gopalan held, for Article 22, which allows preventive detention. Now, to understand this deeper, let us look at the debates. In the debates, the defenders of preventive detention employed a broad set of arguments, ranging from the precarious communal situation to an expression of faith that the new government of independent India would not abuse or exploit these provisions, and so on. And ultimately, the provision was retained. And so some might say this represents the triumph of this whole logic of the state of exception. But I would suggest that a close reading of the Constituent Assembly debate suggests that Article 22 was not an authorizing provision, as the majority held in Gopalan, that it authorized detention, but a saving provision, as Justice Fazl Ali correctly noted, which is that it was a safeguard. It placed limits upon preventive detention. To understand this, let us recall the stormy debate in the Assembly around Article 21, which guaranteed the right to life and personal liberty. The argument was that should this clause have a due process requirement that allows for more judicial intervention, or should it just be limited to the phrase procedure established by law, which would limit the court's role? In the Constituent Assembly, Ambedkar observed that he saw merit in both arguments and would leave it to the wisdom of the House to decide. The House decided to drop the due process clause. Then, in order to provide a degree of constitutional protection to individuals against arbitrary arrest, Ambedkar introduced what became Article 22 of the Constitution. So basically, Article 22 was introduced because the due process language was rejected from Article 21. For this reason, one of the members of the Assembly specifically called it as compensation. Another said it was a caution. The third said it was a compromise. Article 22, Clause 1, therefore required that a person who is arrested has to be informed of the grounds of his arrest and to be defended by a lawyer, while 22, Clause 2 required that any arrested person must be produced before a magistrate within 24 hours, essentially habeas corpus. So after Articles 22, Clause 1 and 2, then followed the preventive detention regime in Articles 22, Clause 3 to 7, which we have discussed a little before. Article 22, Clause 3 began with the words, "Nothing in Clauses 1 and 2 shall apply to any person who is arrested or detained under any law providing for preventive detention." Notably, when Ambedkar rose to defend this article after a fierce 6-hour debate in September 1949, he did it in these words. He said, "I and my friends have been trying in some way to restore the content of due procedure in its fundamentals without using the words due process." This historical background should make the structure of Articles 21 and 22 clear. The phrase procedure established by law under Article 21 allowed the state to deprive an individual of her life or liberty as long as it was done under law, and this law did not have great substantive content. We need not decide the dispute about natural justice or not. Article 22, Clause 1 and 2 were framed as exceptions to Article 21 and required that a person deprived of their liberty be entitled to certain rights and be produced before a judicial authority, core due process requirements. And then the preventive detention regime was framed as a further exception to these safeguards under 22.1 and 22.2. In other words, therefore, a person detained under preventive detention law could not invoke Articles 22, Clause 1 and 2, and, for example, claim the right to be produced before a magistrate in 24 hours. But that is all. Neither the drafting history nor the text of Articles 21 and 22 suggests that the preventive detention regime was meant to be insulated from all the other constitutional safeguards, the rest of the Constitution. Nothing suggests that the preventive detention regime was ever treated as anything other than an exceptional circumstance that could only be justified under exceptional circumstances. The point, therefore, is a straightforward one. The concrete, specific, and narrow framing of Article 22 indicated that states of exception, such as preventive detention, were permitted to exist only insofar as and to the extent that they were expressly authorized by the Constitution and at no other time and no further, and they were to be treated in interpretation as being exceptions. This is what Ambedkar meant when responding to severe criticism from Pandit Thakur Das Bhargav. He retorted, "What I am trying to do is to curtail the power of preventive detention and put a limitation upon it, not authorize it, but limit it." And thus, the core of the Constitution, as Kannabiran points out, was supposed to be emancipatory, and its repressive aspects were meant to be exceptions, not, as Marx said, negations that could swallow up the Constitution's emancipatory ideas. And so, to end, it was in this way that the emancipatory and the repressive impulses of the Constitution came to clash in Gopalan's case. The key question, as a question of constitutional value, to repeat, was, does Article 22 authorize preventive detention, thereby limiting what the court can do because it's there? Or does it place limits upon an exceptional situation, thereby giving the court a hook and a handle to restrictively interpret these laws in favor of individual freedom? An imprisoned communist leader provided the Supreme Court with its very first test, a test that the court failed, and a test that I would argue it has very rarely passed after that. Not in Cooper, not in Maneka Gandhi, and not in every single judgment that has upheld exceptional laws and has upheld detentions under those laws. Gopalan may have been overruled, but the Gopalan approach, where the restrictions follow up the rights, where the state is deferred to in matters of liberty, and where the Constitution, in the words of Marx, becomes its own negation, continues to infect our jurisprudence in 2020 as well. Justice Fazl Ali's dissent, on the other hand, recognized that for the Constitution's emancipatory values, the values of the freedom struggle, the values of freedom, liberty, and dignity to prevail, its repressive provisions would truly have to be treated as exceptions and maintained as exceptions. Imagine what that jurisprudence would mean today as people fight for bail under the UAPA or challenge their detentions in Kashmir and elsewhere. On Independence Day 2020, it is that idea of the Constitution that I submit we must rediscover resurrect and make our own. And it is that dissenting judgment in Gopalan, in that very first case, in that very first fundamental rights case, that provides us with that exact platform upon which we can do that. So with that, thank you very much for listening, and see you again next month. Thank you.